The next topic is, thinking back to our slideshow, is restitution. And we'll use the same format. Over to you, Ruth.
Okay. I would say that in the early 1990s, at the moment of political negotiations at CODESA, the discussions about a new interim constitution, it wasn't initially clear that there would be a separate redistribution program and a restitution program. And it was only really when it became clear that there was not going to be a massive program of nationalization of land, that certain groups of people said, well, we don't just want to stand in a queue and wait for redistribution of land. We were dispossessed of particular parcels of land within our own living memory, and we want a right to return. We want a right to return to that particular land. And so one of the earliest pieces of legislation that was passed in 1994 was the Restitution of Land Rights Act, and it established two institutions, the Land Claims Commission, which is actually properly called the Commission on the Restitution of Land Rights, and also the Land Claims Court. And there were people who came from Canada, from Australia, who talked about the experience of having post-colonial tribunals or courts that specialized in issues of land claims. And this influenced our thinking a lot. Of course, there are three big parameters when we think about what is the right to restitution. And the one is who is eligible. The second is what is the content, what's the form of restitution. And the third is who should pay. So in terms of who's eligible, this was negotiated heavily, and in fact, up until quite late in the process of negotiation, the idea was 1948. But in fact, what was concluded in both the interim and the final constitution in 1996 was that those who were eligible would be people who were dispossessed of property after 1913. And this is not limited to people, of course, who had private property rights, because, of course, most people who were dispossessed unfairly of land had forms of customary and informal rights to land. What's the content of restitution? People are entitled to claim back the land. They're also able to claim comparable redress, which might take the form of cash compensation. It might take the form of alternative land. And who is to pay? And at the time, there was a big debate about who should pay. Should it be the particular owner of the property that is being claimed, or should it be society as a whole? In other words, us as taxpayers who should pay for land reform. And of course, these debates have been changing over time. What happened? Up until the deadline of the end of December 1998, 63,455 claims were submitted. A claim is an amorphous thing. It can take different forms. Sometimes a claim is a single family. Sometimes a claim is thousands of families together. What happened is that by 1999, by the end of 1999, only 41 claims were settled. And this was all going through the commission and through the court. And at that point, the minister appointed a review panel and said, how can we expedite this process? And they proposed two things. The one is, let's go with an administrative process. So we shouldn't have every claim going through the court. We should be negotiating. The commission should come to settlement agreements and negotiations with the claimants. And the second idea was, instead of having to value each claim, as long as the claimants were willing to negotiate and to say, okay, we'll take a cash settlement, how much will the state offer? The state took to offering standard settlement offers, SSOs. And so the vast majority of claims, of restitution claims that have been settled in the past 20 years have been urban claims by individual families or small groups of extended families who have accepted standard settlement offers, 40,000, 50,000, for urban dispossession. The rural story is very different, and if we look at where has land been restored to people, the big provinces are KZN, Limpopo, Northern Cape, Mpumalanga, and the Northwest. It's not surprising that there's not a lot in Gauteng. given that it's so urban. It's not surprising that there's not a lot in the Western Cape, given that dispossession of land started in the Western Cape. And so, there wasn't a lot of black ownership of land by 1913, so many people are not eligible, which is why we now have this big question about Khoisan claims. But I think that the big questions are, what's happened with the Eastern Cape and the Free State? Why are there not more big rural claims? Of course, it's complicated to recreate communities, often people who don't know each other, whose grandparents might have known each other, but now they've been dispersed across the country, and they're trying to come back and recreate communities, often with different interests and different assets. There's been a big story, particularly in some of the high-value areas of the country. I think that Limpopo is a big story, which is where the state has said, you are a large group of poor people claiming high-value commercial farmland, and we are not going to give it back to you to use as you wish. Rather, we would like to have a commercial partner, a strategic partner, who will operate these farms on your behalf, and you will get priority access to employment, you will have a shareholding, and so on. So this is a model that has been developed where the strategic partners get a percentage of turnover. Often the community claimants get a percentage of dividends. One of the examples that we've done quite a lot of research on is the Levubu Valley in Limpopo, but there are many others across the country. What are the processes of restitution? It's very important to understand that there has to be a validation process where the state investigates and says, okay, you were actually a holder of a property right. That property right was unfairly taken away from you. It was after 1913. It was due to a racially discriminatory law and practice. So that's quite an onerous process. Secondly, there's a very onerous process of verification. Who are you and what's your relationship to the person who is dispossessed? And in many cases, this means creating family trees, getting powers of attorney, who's living in Joburg now, who's living in Bizana, etc. It's a complicated process. And so one of the things I would emphasize is that for the state, doing restitution is much more complicated and costly than doing redistribution. With redistribution, the state can just go and say, you want land, here's land, we're going to give it to you. But with restitution, there's a huge and burdensome bureaucratic onus on the state to go through this burden of proof. What is now the situation? I would say the high-level panel report gives a very bleak picture because, of course, in 2014, it was announced just ahead of the national elections that the state would, that there was a bill before Parliament and that the restitution process would be reopened. And this was quite linked in with the politics around the Western Cape and the Northern Cape and the demand for Khoisan claims to be entertained. But in fact, they haven't been. What happened in the reopening of land claims in 2014 was rather that those who missed the deadline of 1998 were allowed to submit their claims. And there was subsequently a constitutional court case where the existing claimants objected to the fact that now new claims are coming in. And what the constitutional court said is that those claims that were submitted by 1998 must take priority. Those must be resolved first before we entertain the new claims. Now, here's what our backlog looks like. 35 years to resolve the existing claims that were submitted by 1998. Currently, we're sitting at around 160,000 new claims, and at the current pace of settling claims, we're looking at about 143 years to do that. So there is a massive political question, which is about a political promise that was made for restitution, and in many ways, the unfeasibility of it being realized in practice anytime soon. Big stories, what should we look at? I think nobody has really looked at the question of cash compensation. Most people claiming restitution have taken cash compensation. How have they used the money? Has it made any difference to their lives? Do they feel that justice has been done? We don't really have a lot of storylines around that. Secondly, who are the strategic partners who are getting these very, very lucrative deals and getting access to commercial farmland bought by the state? And are they benefiting? Are the communities benefiting? I think that there's a big story about claims that are officially settled, but they haven't been implemented yet. In other words, the state has said, we sign a settlement agreement, and in a future financial year, we will actually fund this and do it, but we haven't done so yet. We don't know what's the status of these claims in limbo. And of course, there's a huge politics around traditional authorities. And what we saw in the run-up to 2014 was that a lot of communities who were claiming land were saying, we know that actually there's a traditional authority, there's a chief, who's claiming jurisdiction over our area, and they're now lodging counterclaims. So I think that that's a fourth big important question. Thanks.
Ruth.
Who pays? The answer, of course, has been that we as a society pay. So let's be very clear that the willing buyer, willing seller idea does not exist within the Constitution. It was a policy choice. What the Constitution says is that the state can expropriate for land reform purposes. It's chosen not to. So, within restitution, the state has chosen to negotiate with existing owners whose land is being claimed. And of course, if it's not an open market, if your property is being claimed, you are the only possible willing seller. And so there have been cases of corruption and collusion where government officials have got into cahoots with particular property owners who have agreed to inflate property prices. So there have been some scandals in particularly Mpumalanga and Limpopo around that. But typically, either there's a market price to be paid and the state is buying out properties at market price, and in some cases even paying a premium over and above market price to get the particular properties because there isn't an open market.
So the owner has always been paid?
So the owner has always been paid. So that's why when we come to the debate later about expropriation without compensation, up to now there's been no expropriation, and compensation has always been either at a market-related rate or negotiated directly. Why is the 90% for cash? I think it's a complicated story. And one of the reasons is that there is a false choice. There's a false notion that people can choose, the money or the box. Do you want the land or the cash? But in fact, if you're going to have to wait for generations, if you're going to have to wait until your grandmother dies before you can even claim back that land, in many cases it's a false choice. Bear in mind also that where the Commission, particularly where there's been an appreciation of the property values, so we're looking at suburban land, we're looking at Rondebosch and Bishop's Court, we're looking at Cavendish Square in Cape Town is under claim. So the state is going to people and saying, you can wait for years and we will contest this in court, or here is a standard settlement offer. You can take cash now. And so I think that the delays are actually making that a false choice. In terms of research, Ben, do you want to answer?
Sorry, what was the question?
The question was around, what was the final question, the research question?
How people prove they had...
Oh, yeah. So in fact, I think that one of the things that happened in the 1990s that was very interesting was that the ways in which people can prove that they had a historical claim to land, that they had that land, and that they were unfairly dispossessed. That the forms of research included oral histories. So literally some of the claims involved having old people going on trips around the countryside and identifying key sites and what was the oral history and the knowledge of that landscape. So we are not entirely constrained by formal title deeds. We're not entirely constrained by formal archival evidence. There's been quite an opening out around oral history.
if I could just add to that, it nevertheless requires proper historical research. What the report to the high-level panel, in part written by one of our most eminent historians, Peter Delius, and one of his former students, Michelle Hay, reveals is that in recent years the research has been very, very shoddy, and that there are many claims that have been accepted which are in fact not valid. The infamous, probably corrupt Mala Mala case, where nearly R1 billion, that is a quarter of the department's annual budget, was paid out to one single family for a nature reserve just south of Kruger National Park and settled out of court, according to Professor Delius, was not a valid claim. What they also suggest is that what's been happening over the last 8 or 9 years is that people have been put under great pressure to amalgamate their claims in the interests of speeding up the process. So very large, dysfunctional communal property associations are being created. People are being forced to get into these together with people that they've never had anything to do with, purely in the interests of officials. These are dysfunctional, they're falling apart. Furthermore, the hard copy records of claims were digitized a few years back, and many of the hard copies have now been lost, but there were errors in the digitization, and so the records are in a big mess. The Commission has lost capacity. The Land Claims Court now has no permanent members. It's the people appointed on an acting basis. So the institutional capacity to implement this very demanding and rigorous process of restitution has gone to waste. So the Amendment Act, this is in the face of these problems, opening up claims for another 5 years to potentially 400,000 new claimants, is a slightly crazy thing to do. Really the motivation was getting votes, as well as offering land to traditional leaders, a key beneficiary of the current ANC policy.
The reality is that if people want to contest a claim, remember what I said is that in 1998, the legislation was changed that said you don't have to go to court. The state can negotiate with claimants and it can settle out of court. But if they cannot, but they still need to prove that they have a valid claim. They still need to prove who they are in relationship to the people who were those who were dispossessed. So it's still a very long and onerous process. But you don't have to go to court. Yeah. So I think that I think that there's a lot of potential for individual human interest stories that also relate to big policy questions, which is people making these very, very difficult choices. And of course, the difference between living in Khayelitsha or Mitchell's Plain, but getting 50,000 rand versus getting your house back in Rondebosch, these are huge differences. And people are facing really complicated questions. And of course, there's a wider set of questions, which is about, is this reconciliation? Remember, restitution is both about a material restoration of an asset, but it's also the idea that there should be reconciliation, that there should be a sense that justice has been done, that an injustice has been resolved. And that's not clear. And of course, restitution, even where you redistribute the land, where you restore the land, doesn't necessarily lead to people having a better livelihood. So restitution and its relationship to development is not clear. I like to quote an interview with an elderly woman in KZN from the 1990s, and she was asked, now that you've got your land back, has justice been done? And her answer was yes, but justice alone is not something you can eat. So I think that these questions about the relationship between restitution as a material question of assets and ownership versus a sense of reconciliation, justice, and identity are quite complex.
Just to add an interesting restitution case in Kwazulu-Natal, in an area between densely settled communal areas and commercial farmland, several farms are under claim. Now, in that particular instance, there are people living nearby and some on that land, part of the original communities who want the land back. There are other members of those communities who, over the last 45, 50 years, have moved to towns and have established a different life. And they want cash settlement. Actually, what they want is it's a proposal by the white farmers to turn this into a private nature reserve. And some members of the claiming community are happy to go with that. Others say, no ways, we want our land back. That claim is not resolved. The different parties cannot reach an agreement. The original community who was dispossessed has now differentiated. Some have moved on. They don't want to return to the land. Others do. Others could make a go of it as small-scale farmers. Government has insisted that they reach a unanimous decision. Government does not accept that there can be differences within the claiming community. So these are some of the fact that we are looking back in time and are trying to reconstitute a sense of community ownership makes restitution a very difficult and complex undertaking.
Levubu is interesting because there were 16 farms in a very, very high value valley, all under claim. And so what had happened is, in the process of homeland consolidation, large numbers of people were moved over the Soutpansberg Mountains into what became Venda. And now they're all claiming back these high-value farms. And it's subtropical fruits, it's macadamia, it is mango, etc. This is big export horticulture. Now, when people are claiming back that land, the state has said, there's absolutely no way that you guys are going to come back and reoccupy this land. We're going to have to find another way. And it's been actually quite a complicated process. In the first phase, it was actually a group of the existing landowners who sold their farms to government and got the market price, but then continued to occupy the land as strategic partners. So the people who were dispossessed remained in Venda, and the white farm owners remained on their farms, but were paid out full market price. But there was a cooperation agreement and a shareholding agreement. So yes, there's enormous pressure, and in fact, that fell flat. The whole cooperation deal, the strategic partnership deal, fell flat. And there have been 3 new rounds of new commercial partners coming in, and the state will still not allocate the farms for people to reoccupy. Instead, they get preferential access to employment. And in fact, what we found is that 40% of the existing farm worker force have lost their jobs. Because now, of course, it's the claimants who must get preferential access to the land. I think that the state is putting enormous pressure on people to come to some kind of agreement that will keep commercial production ongoing. And one of the reasons is that a lot of commercial agriculture that's under claim, their interest is not so much we need to retain access and ownership of the land, but we have downstream processing industries, right? So it was the nut cracking factory, and it's the juice production factory, and it's all the other downstream industries. And their concern is that they want to keep the same production online. So they don't want the claimants to take over the land and to change the land use. So their interest is not necessarily owning the land, but ensuring the value chain.
Just a final word on Levubu. The strategic partners mostly having exited now. Those farms are now being run by these communities through CPAs as commercial enterprises. Most of them are struggling, but there are 1 or 2 real successes. And the interesting question is why? So the Ravele community in Levubu are making a real go of it. They're producing a lot of profit every year. And why? My former PhD student, Chalila Manenja, who works for Parliament, is a good person to go to. He can give you insights. And it's one of those rare success stories in land reform, where we have a large-scale model, it's community-owned, and the community is making a success of it. By the way, in Levubu, I think there's something like 400 farms? I don't know, there's several hundred farms. Actually, restitution claims have been settled on only 16 of them. And government is saying, we've already spent too much money on this. The other claims, we're not going to consider them. So, I'll tell you what my real question is. Was restitution a good idea? There's all sorts of complex and knotty problems. Okay, I think we're moving to the next session. No, I don't think they're actually proposing the repeal of the private members' bill is an amendment to the Amendment Act. And it's basically does one good thing. It says we will have to resolve all the 1998 deadline claims before we resolve the new claims. Other than that, these massive problems with how restitution is structured are not addressed. It's a good example of how an Nkwinti-era bill needs to be set aside. Can Parliament, can the Portfolio Committee have the courage to do that? The Portfolio Committee has taken its courage in its hands with respect to one key issue raised by the high-level panel report. That is the Ingonyama Trust, which we will deal with in the next session. So there are some hopeful signs. Actually, it's the big cheeses in Parliament, the speakers, who need to take responsibility. And you might have seen an article, I think it was last week or the week before, by Ninka Claessens talking about the high-level panel report and talking about the fact that Parliament is not acting on its recommendations in this period where there's a great deal of uncertainty. So that's a key issue to follow, I think. Okay, so next session is issues of post-settlement support and what I'm going to call agrarian reform.